of the EU Strategy for Data. My name is Claudia Tapia. I'm the chair of 4IP Council, and I will be your host today. As you may know, 4IP Council is a non-profit council developing high-quality academic research on topics related to intellectual property and innovation. This webinar is one of many we're running this year. But we also conduct education activities, including those promoting innovative small and medium enterprises to grow their businesses using intellectual property. Visit our website for a range of free materials. The slides and a recording for this webinar will be made available tomorrow on our website. If you have questions for the speakers, please post them in the Q&A area on your screen. I will be reading them after the presentations. And without further delay, please allow me to introduce you to today's great speakers. Ginevra Bruzzone is an economist specialized in competition policy and EU law. She is senior fellow at the Lewis School of European Political Economy in Rome, where she teaches EU competition policy and the internal market. She is also Deputy Director General of Asonime, a private think tank in Italy, where she is in charge of enterprise, competition, and the digital agenda. Conrad De Bakkere is a professor of technology and innovation at the Faculty of Economics and Business of KU Leuven. His research has focused on the design of technology and innovation management practices and policies, the development of indicators for measuring the societal and economic impact of science and innovation policies, the role of entrepreneurial universities in economic development, and the management and growth of technology-intensive companies. Since 1999, he has been actively engaged in technology transfer activities as managing director of KU Leuven Research and Development. Over the last 20 years, this has led to relevant experience with the development and growth of technology-intensive, innovative entrepreneurial companies. They're both really impressive CVs, and we are delighted to have you here today. So without further delay, over to you, Ginevra.
Thank you very much. Today we will focus on the EU strategy for data, its challenges and its opportunities. And the starting point is that obviously times are changing. That digital technologies have already changed the daily life of individuals, of companies, of public administrations, and will continue to do so with huge potential benefits, both for people and for society as a whole. However, next, all these advantages cannot be taken for granted. The positive impact of the digital transformation on our economy, on our society, strongly depends on whether we have an appropriate institutional framework and appropriate public policies. Think, for instance, of the need for adequate connectivity, the need for trust in online transactions, including cybersecurity, protection of personal data, consumer protection. If you don't trust online transactions, you don't use them in a proper way. You don't use them. Think of the importance of the interoperability of technical solutions, and here also public policy plays an important role. And we need public policy because no one has to be left behind. Therefore, we have to focus on how to ensure that small and medium-sized enterprises will be able to exploit the potential of the digital ecosystem. We have to ensure digital skills and the qualification of the workforce. So there are challenges that have to be met by public policy. Next. And we have specific challenges related to the role of large online platforms, of big techs. The idea is that we have these very large companies with huge economic powers, but we still have to understand how to assess and address this power. And there are several policy areas involved. Think, for instance, of protection of personal data, but also the freedom of information, how to deal with the removal of illegal or harmful content online, how to ensure the maintenance of effective competition in digital markets, how to prevent the unfair exploitation of market power, and so on. So specific challenges related to the role of platform. Next. And all these policy challenges have to be met by means of a strategy. A single policy initiative is not sufficient. We need a strategy. And Europe started a long time ago. The process started more than 10 years ago with digital agendas, digital strategies. We started in 2010 with the European Digital Agenda. Then we had the Digital Single Market Strategy in 2015. And at the time, the focus was on the internal market, level playing field, protection of personal data, proper application of competition rules, traditional IP. And there was not, for long, there was not a focus on data as an input in the value chain. But things started changing. For instance, with the regulation on the free flow of data in 2018, the idea is that the member states should remove all unjustified restrictions to the free movement of data cross-border, and should encourage codes of conduct and to ensure the data portability. And we had in 2019 the Open Data Directive, which modernizes somehow the 2003 directive on access and use to public sector information. Next, please. And if we look at the recent strategy, the strategy of the von der Leyen Commission, we see that the digital transformation is at the heart of the EU strategy for sustainable growth. And in particular, we had a strategy adopted, so-called Shaping Europe's Digital Future in 2020, which was recently updated by the Digital Compass. And the vision is focused on three pillars. Society. European society should be powered by digital solutions strongly rooted in our common values. Technological sovereignty, starting from the integrity of data, infrastructure, and networks, and broad availability of non-personal data. The objectives mainly are a technology that works for people, fair and competitive economy involving companies of all sizes, and an open, democratic, and sustainable society, technology, trust, sustainability, and so on. If we focus on the strategy for data of the current Commission, next, please. We have a communication which is called the Strategy for Data, and interestingly, it announces regulatory initiatives, but not only regulatory initiatives. For instance, it contemplates very important initiatives on the construction of so-called common European data spaces in areas such as industrial manufacturing, the Green Deal, mobility, health, energy, agriculture, and so on. Then we have a set of proposals. And we will discuss these proposals later. A proposal of a EU Data Governance Act, some regulatory proposals on platforms, a Digital Markets Act and the Digital Services Act, and a package on artificial intelligence, which includes a proposal of regulation on the admissible uses of artificial intelligence, but also a coordinated action plan for the development of artificial intelligence in Europe. And forthcoming, we have a proposal for a data act, which will deal with B2B and B2G, business to business and business to government data sharing. But what these this is the plan, but what are the challenges? Cohen, you go on.
The European idea is to create an economy, a digital economy that can be globally competitive, and at the same time understanding a couple of challenges with big data in the world, but also in the European Union. As Ginevra said, the important element in the digital strategy for the data strategy of Europe is to remove obstacles and barriers to the free movement of data. But at the same time, there are ongoing technological developments, for instance, Internet of Things, that increase the production of data quite exponentially, that also create questions and challenges with respect to value creation and value capture of everyone involved in the value chain of IoT-based data creation. And this, of course, creates challenges, but it also creates opportunities for Europe to recover positions in the global digital economy. But this also requires an in-depth understanding of novel market dynamics in the digital economy, and understanding the design, development, deployment of new business models. The European challenges are highlighted here. First of all, there is quite some fragmentation of the internal market. Government access to private sector data differs quite importantly between countries. At the same time, the access to public sector data is quite different between countries, so there is a need for harmonizing this access. There is also, given the evolutions in the field of artificial intelligence and the need for lots of data to train to use algorithms in training and coming to new insights using machine learning technologies, also asks for data availability for reuse of data. So the need for data available for reuse is a second important challenge in our European market. We also see that because of the power of platforms, because of the joint value creation in value chains, thanks to the Internet of Things applications and technology, there are imbalances in market power and in bargaining power between firms. Think of the big tech challenges we all face in Europe, and those imbalances need to be addressed with proper frameworks, with proper regulation and legislation. And of course, as Ginevra already referred to, the basic European, fundamental European values, the need for enhanced control on own personal data by the data subjects, by all of us, and on non-personal data by entities who contribute to the creation and the collection of those data is in Europe an important, not just an important challenge, but also a value to be respected. And that's why the issue of personal data, and we come to GDPR later on, is a very important element in the data approaches within Europe. Of course, when you want to create an open market for data, free movement of data, remove barriers, then interoperability issues are of tremendous importance. So it is not without reason that Europe places a lot of attention on interoperability issues in order to make the European digital market more vigorous and more vibrant. We also have the issue of cloud services. I'm happy to refer to the Gaia X platform that is being developed by Europe, within Europe at the moment, because those cloud services and data location, think of the Schrems II legislation and arrests by the European courts, need to be addressed, and those cloud services face an issue of concentration that also is a challenge in our digital market. Cybersecurity, of course, every day we see cyber attacks, we see the need to better understand and better cope with security issues, and this is also an important element of the European strategy for data. And last but not least, the talent base, the lack of skills, big data, artificial intelligence, machine learning, applications, cross-sector applications require a lot of skilled people, a huge talent base, and Europe also comes to the conclusion that we need to invest in skill development, in upskilling, reskilling of our workforce in order to address the challenges to come to a vibrant digital market. Next. Important in this whole approach, and definitely from a public sector perspective, is the access and reuse of data and the need for a vision to access and reuse data. And digital markets are strongly based on innovation. Innovation is their main driver. And this means that we need to bring innovation and market dynamics together in our frameworks on digital transformation. And it is not just about access, it's also about data generation, it's also about use of data, including commercial exploitation. And this means that balancing acts have to be engaged with, and that we have to understand what IPRs mean. We should avoid free riding, hence the need for a legal framework on access. We have to take into account heterogeneity of data, personal versus non-personal data, investments for creating the data collection and the data dissemination, and the economic nature of the data. So this means balancing both commercial interests, security, societal interest, and fundamental European values involved. Next, please. The Open Data Directive wants to make sure that data are available for maximum reuse, but taking into account limitations because of third parties holding intellectual property rights, carve-outs for sensitive data, avoiding distortion of competition. Also, academic research should be distributed, should be available according to the FAIR principles, findable, accessible, interoperable, and usable information, taking into account IPRs and commercial interests. And of course, we should also take into account economic interest and not directly exposed to competition, but only for those data for which the entity has decided to permit reuse. And this brings me to the last, next slide. It also means that Europe is taking into account what we call high-value data sets. It's one of the main novelties in the Open Data Directive. And these high-value data sets are reused, associated with important benefits for society, environment, and economy. Public sector bodies should make those data available for free, disseminate them in a machine-readable format, and by means of application interfaces throughout the EU, and have them as a bulk download relevant. Thematic areas are being defined at the moment, but you see a number of them having been delineated in the meantime, but the list is still under construction. And we have to consider the impact on undertakings in terms of cost-benefit analysis, need for specific investments, impact on competition, fairness of competition, etc. Ginevra?
Next, please. And so far, we have considered the data held by the public sector, by publicly controlled undertakings, by public authorities. What about data held by private companies? Here, the general principle in the EU is freedom of contract. However, with some exceptions so far. For instance, for antitrust, we have that if a company holds a dominant position, refusal to supply access to essential data may, under certain conditions, be considered an abuse of dominance and is prohibited. And the conditions are that these data should be indispensable to complete the refusal, in case of the refusal, there must be a significant impediment of effective competition, and there should be no objective justification for the refusal to deal. But if these conditions are there, then the refusal to deal, the refusal to grant access is an abuse of dominance. And then we have some sectoral provisions requiring undertakings to grant access to some kind of data under specific conditions. And they include, for instance, why? Because of some public interest reason, for instance, in order to encourage competition, in order to promote innovation. Think, for instance, of access to information concerning the maintenance and repair of motor vehicles, access to information related to intelligent transport systems and the safety of roads, access to information relating to customers of payment services, the PSD2 directive, which whose aim was to promote competition in the payment services market. And so the general principle is the freedom of contract. And so far we haven't other general rules in the European legislation. We have guidelines by the Commission, and in these guidelines there is a principle of concerning co-production. In case in the case in which data are generated as a sub-product of the use of a good, for instance, let us think, for instance, of the use of a sensor in agriculture. The Commission suggests that there should be an acknowledgement of the shared value creation. And these principles probably will be expressly contained in the forthcoming Data Act. Next, please. And what about the supply of private sector data to public sector bodies for the fulfillment of their institutional tasks? Still, we have some principles, and the guidelines by the Commission suggest that requests from the public sector to the private sector are acceptable, but they should not go beyond what is necessary and proportionate for pursuing objectives of public interest. The duration, the purpose should be clear, the collaboration should be transparent, and the legitimate interests of the companies should be respected. Companies should also help to assess the quality of data, but when cooperating with the government, should not be required to improve the quality of data in question. They just have to inform the government about the quality of their data. Next, please. And so far, we have discussed the rules concerning conditions for access to data held either by the public sector or the private sector. The proposal for a Data Governance Act is complementary in some respects because it is not about the rules concerning access to the data, but it is about fostering the reuse of data, both in public and in the private sector, by creating a governance framework, an institutional framework capable of increasing trust in data sharing. So it is not about new conditions for access, but it is about an enhanced framework for the reuse of the data held by the public sector, which are not open because, for instance, they are covered by intellectual property rights, or because of commercial confidentiality, or they are personal data. They can also be shared under specific conditions. The second pillar of the forthcoming Data Governance Act is the establishment of independent data intermediaries, which will help natural persons, individuals, and companies to share their data and keep control. And they will help both for personal and non-personal data, a complementary tool compared to the set of rules, for instance, contained in the GDPR, which tell us you can do this, you cannot do this, but how to keep control, how to manage, how to extract value from your data. This kind of intermediaries, which will not be active in the data markets, but will be just act as intermediaries and will be supervised, should be helpful in this respect to make individuals and companies feel an enhanced control on their data and how their data can be exploited. And the third pillar is about fostering data altruism organizations and to make it easier for individuals and organizations to give their data for free for the public good. Next, please. And finally, we go back to rules concerning the access to data, and in this case, access to data held by the large online platforms. Because in the proposal for a Digital Markets Act, we find some harmonized prohibitions and obligations which will apply on large platforms which are designated as gatekeepers. And these prohibitions and obligations include some rules on interoperability and on access to data. And some of these new constraints, which if the Digital Markets Act will be approved, will apply to a gatekeeper platform, concern enhanced control on own data by data subjects and business users in some cases. For instance, there is a request for consent in case of combination of personal data, which goes beyond the constraints resulting from the GDPR or rules on the portability of data. But some rules aim to ensure fairness. For instance, the platform should not use data non-publicly available generated by a business users if the platform uses this data in competition with the business user, so fairness. And the most controversial constraints concern how to promote contestability of digital markets. And in this case, there is, for instance, a rule whereby a gatekeeper platform should grant access to data resulting from search engines on friend terms. So a direct obligation to share a kind of data without the conditions required by the traditional application of competition rules of antitrust law. If you are a gatekeeper platform, you should, according to the proposal of the Digital Markets Act, you should be obliged to grant access to data of your search engine on friend terms. And maybe this is a little too rigid, taking into account also incentives. So Cohen, you can go on and discuss this.
Thank you, Ginevra. Next. So as Ginevra said, there is a lot of work to be done on the relationship between data, competition, and innovation. There are a lot of assumptions that underpin the Digital Markets Act, and there has been an impact assessment, and there has been some analysis of that impact assessment that was recently published, amongst others by David Teese at the University of Berkeley, at the University of California. And there are a lot of assumptions, and they're highlighted here, a lot of assumptions that need further understanding. For instance, the Digital Markets Act will cause R&D spending to double with related increases in employment. These are assumptions that definitely need further assessment and that need further underpinning. A significant amount of merger and acquisition activity will be replaced by R&D spending on a one-for-one basis is another assumption underpinning the reasoning behind the Digital Markets Act and the way we think about creating contestable markets. Well, once again, this requires and invites for further analysis and understanding. There will be a lot of socially beneficial and value augmenting R&D spending done. Also, this assumption, which is an important one, needs further attention and clarification. It's also mentioned that the DMA's obligations are narrowly targeted so that they will have no negative effect for users with respect to costs, quality, functionality of core platform services today or in the future. This is once again an important hypothesis that we would need to further understand. There is a lot of emphasis on what we call competition in the market rather than competition for the market. Also, this point of view requires further understanding. The same for the regulatory fragmentation caused by diverging national approaches, and the impact assessment makes the statement that in its absence, so in the absence of the DMA, 100% of cross-border trade intermediated by online marketplaces could be lost by 2025. This is a very strong assumption that also needs further validation. And of course, if you create the type of monitoring that is envisaged, you need offices and staff to do so. And so the question is whether the Commission can do this with a few dozens of employees. So I just wanted to highlight this to show that the Digital Markets Act has very important objectives in terms of competition and in terms of innovation, stimulating the European competitive position globally by using and mobilizing the full force of data. But on the other hand, there are a number of impact assumptions that definitely need further clarification. And that's also what David Thies in his April paper advises us to do. Next. Because when we think of competition, there are two views, two perspectives to take competition into consideration. The first one is what we call static competition. And static competition means that we do an economic analysis of a specific sector and what happens in that sector, in that market. And of course, this static competition has a long history. It was around in the industries that are characterized by tangibles, like, for instance, the steel industry, the automotive industry, etc. But a lot of economists think that the static competition perspective should be revisited because intangible goods, like, for instance, intangibles like intellectual property, collection and use of data, the digital economy, requires a much more dynamic economic assessment. And this brings us to the Schumpeterian dynamic form of competition, which is driven by the processes of creative destruction, as Joseph Schumpeter called it, the eternal gales of creative destruction, which means that boundaries of an industry, boundaries of a market are much more fluid. There are entrants like, for instance, big tech that enter a market where normally they were never before. Entering, for instance, a financial market, or entering, for instance, the automotive market and other ones. So we should be more open to the dynamic nature and what we call the broad spectrum nature of competition, where assets, where capabilities are continuously recombined to come up with novel products, novel services, combinations of products and services, etc. So that's a very important distinction underlying the DMA and the link with competition and competition policy. So a question to move, or an insight to move from static competition perspectives to more dynamic competition perspectives. And there is also the competition, the fairness of competition. And here, Oliver Williamson, the Nobel Prize winning economist, advocates to avoid exposed recontracting. So if Europe wants to excel in creating a digital economy and creating digital champions, we should avoid to stimulate them to compete aggressively, taking into account competition law. But then once they become successful, start looking at them with all kinds of pervasive regulation and the way they have to open up IP and data to rivals. So this is a balancing act, and probably we need to gain better understanding and more in-depth understanding as to how to do this. This brings me next, please. So we should understand that the sharing of data is not an objective in itself. It's a tool to support the economy, a competitive economy. And this means that public policy should consider an ex ante perspective. And it should take into account the incentives of undertakings to collect and process data to ensure their quality and to come up with new applications, with new uses. With innovations to briefly summarize. The importance of enablers, common data spaces, installation of trust, the governance of data will also become extremely important. For instance, with respect to sensitive data like health-related data, Europe has a very strong health economy. Well, we should make sure that we use the proper balancing to, on the one hand, preserve the fundamental values of European citizens, but on the other hand, make sure that we can have a competitive life sciences industry, taking into account the potential of healthcare and health-related data. And data based on silos should, of course, be overcome. And this means that there should be rules to share data, personal data within ecosystems and approaches that can remove rigidities on sharing those data, but of course, taking into account commercial interests, intellectual property interests, etc. Next. So Europe has to seize and can seize a lot of opportunities to become a data-driven economy, but at the same time, it should foster contestable and fair markets. And this means that we have to take into account principles on modeling and data analytics, automated decision-making and profiling, direct marketing, repurposing of data, transfer of data to other organizations, and the right of subjects to control the data transfer from one controller to another one. So a lot of opportunity, but also a lot of challenges. And I would like to end with the next one. It also means that when we talk data, we have to talk about the directives and the accessibility and use and reuse of data, as was highlighted. We also have to make the link of data to innovation and innovation policy and competition. And at the same time, there is quite some work done, and this goes back and concludes with the fundamental values that were highlighted in the beginning. How do we use data in an ethical way? And I want to conclude referring to this very recent paper by the World Economic Forum, Ethics by Design, where 3 questions are being asked with respect to the digital economy and the use of data. And the 3 questions are very simple. Is it legal? Is it compliant? Is it right? And I think in Europe, we are in the midst of this debate. There is a lot of opportunity, but we also have to be careful that we allow companies and markets to thrive and the European economy as a consequence to thrive. Thank you.
Thank you. It's been very, very interesting presentation. I don't know, Ginevra, did you have any final message, or should we start in the Q&A?
We can start with the Q&A, yeah.
Right, because in the meantime, we received some questions, very interesting questions too. And I would like to use the time to go through them. So since we started with you, Ginevra, maybe this time we'll start the Q&A with Conrad. The first question we have here is, how does EU digital and data strategy differ with what we see in China and the US? What does Europe need to do in order to have a different approach and achieve economic strength?
So thank you for the question, Claudia. Europe has a big advantage at the moment, and we should turn this advantage into a strength. And this advantage has to do with the protection of the individual. We really want to make sure that every person is owner of the decisions relating to her or his personal data. So that's a strength. And I think it's a strength which makes us different from US, from China. And we should capitalize on that strength. But at the same time, and that was, I think, one of the core messages in our presentation and our paper, we should make sure that companies can still thrive, that companies can use those data, that intellectual property can be protected and can be used. And this is a balancing act, but it's a balancing act that can work. And at the same time, you see a lot of technology evolution that may further enable this, this dichotomy of personal interest and personal control to thrive alongside the economic benefits that can be obtained. And for instance, there are evolutions in encryption technology. I'm just referring to fully homomorphic encryption technologies that are around the corner, or multi-party computing technologies that are around the corner, that will allow us to fuse both. And so I think if we can achieve this, then Europe will be an area where we have a digital economy, where we protect personal data control, and where we can have trust by the individual and in the marketplace, which should go hand in hand. So I'm quite optimistic, but it's a lot of hard work, and we should not over-regulate on one side, making impossible the other side.
That's interesting, because it goes very nicely with the next question that we received, which is, are we sometimes over-regulated? And they're writing, does GDPR need improvements? In other words, should we configure GDPR 2.0? And if so, what should we put in its agenda? So it would be very interesting to know, in Ginevra, think about it.
Thank you, Claudia. It's a very interesting question. Sometimes, indeed, we tend to over-regulate, but I think that the GDPR is a very important, ambitious and important piece of legislation, and it has become a kind of a model globally, even it is a difficult model, a challenging model. And it is based on very broad principles. Then we have the GDPR and also e-privacy rules, which in some cases are even stricter. For instance, when you refer to the legal basis for access to data, to information contained in a device. And with the GDPR, the problem is not so much the principle, but the principles, but the fact that we have a very broad notion of personal data, because personal data is a data which can directly or also very indirectly be referred to a natural person. And this indirectly means that in some cases, data which we think, well, these are not personal data, they are not about fundamental rights, are covered by the GDPR because indirectly they are personal data. And the GDPR is based on the principle of data minimization. You should minimize the processing of data. And how can this fit with a vision whereby we should maximize the use of data in order to spur artificial intelligence in Europe? This is a great challenge. And in my view, the solution cannot be rewriting the GDPR. It is too difficult. The GDPR is there. What we can do is work on the specific ecosystems, on the common European data spaces, on specific issues. Think, for instance, of exchange of data within the automotive sector. So because this can be very important for insurance, for car sharing, for vehicle development, for vehicle maintenance, and so on. But if this exchange of data, this processing of data should follow strictly all the rules of the GDPR, it becomes very, very complicated. with an approach based on ecosystems, on common European data spaces, we may be able to address specific issues and simplify some approaches based on the absence of serious risks for fundamental rights. Even if we have this broad notion of personal data, we can say, well, for data concerning mobility and e-mobility, we can simplify. The legal basis can be this one, and so we can succeed in combining the ambitious GDPR, which is extremely important because of the protection of fundamental values, with an approach which becomes a little more practical when there is not an issue concerning really the protection of fundamental values.
Thank you. Conrad, I'm not sure if you wanted to say anything else additionally, or we can go.
Well, no, I think that Ginevra explained very well what has to happen. The focus on ecosystems is an extremely important one, because in ecosystems you can design approaches where you close certain loops within the ecosystem so that essentially GDPR becomes more workable. And this means that in the future, and that's of course the challenge with the platforms we have today, but that competition may become competition between ecosystems and not just between organizations anymore. And that's why dynamic view on competition is so important, because the boundaries of competition are becoming more fluid and change. But the ecosystem approach, and I think thanks to GDPR and the need to make it workable in a number of instances, that ecosystems will gain in importance as economic entities in the near future.
Great. Here we have another question saying, what other than data regulatory actions are needed for Europe to nurture strong global digital players that fuel a competitive data economy? So all, as you see, very similar questions. I don't know, Conrad, would you like to?
Well,
or it's basically the same as we.
I think we need a number of policies that converge. So the strategy for data is essentially about access, use, reuse, repurposing of data. But at the same time, we need to be able to stimulate through innovation the growth of companies that can become global leaders in a number of areas. And that's why, for instance, what the European Innovation Council does is so important, because it attempts at creating also European unicorns, not just American or Chinese unicorns. So if Europe wants to succeed in the digital economy, we need innovation, we need growth of companies, entrepreneurship, and stimulating that scaling of companies. We need a fair and contestable competition policy, and we need to arrange the access, reuse, repurposing of data in that framework. So I think it's a combination of those policies that will have to make the difference. And therefore, it's so important that, for instance, competition policy, innovation policy, and digital data directives and data strategy are aligned with one another, and that the Commission thinks carefully about what they mean in terms of not just competitiveness, but also in terms of growth and company formation. So it's an and issue when it comes to policy.
Indeed. Ginevra, we hear a lot about open data. When is open too open?
I think that when we say open data, we think it is an obligation to consider this data open. So the issue is how to design the rules, how to ensure that the rules imposing the openness of data are proper rules. And the approach should be the usual approach we use when we face issues concerning better regulation. So we have to identify an objective of public interest. We have to assess whether the obligation is necessary and proportionate to attain this objective of public interest. We should assess whether there aren't undesirable side effects. We should assess the impact of competition, because, for instance, an approach to the openness of data may be very good in the short term for competition, but maybe has a negative impact on incentives, and in the longer term, it has an adverse impact on competition. It reduces dynamic competition. So I think that in order to assess whether a rule imposing openness is appropriate, we should ask ourselves these questions. We should not take it for granted that everything should be open. This is not the general rule. Openness is very important. It may be necessary to attain some objectives, but should always be something which is targeted and proportionate, and we have to take into account the side effects.
Thank you. I see here another question. I think it's a reaction from Conrad's statement before. Do you expect Europe's 100 billion euros fund to bolster European companies in the competition against the Google, Apple, Facebook, and Amazons of the US to succeed? Would this have significant consequences in the world of data?
Well, let me start saying I hope it does. Only time will tell, but 100 billion is a lot of money, and not just the 100 billion, but also the leverage that can be obtained through the 100 billion is extremely important. But at the same time, Europe should not try to imitate or copy the GAFAs, but should come up with own solutions. So we have to rely on our entrepreneurs. And I'm just a bit, well, it's related to data in an indirect manner, but there is a lot of discussion today on a European semiconductor industry, and as we all know, semiconductor sensors, etc., are the basis for Internet of Things. But then the question is, should you just copy or try to get a big semiconductor manufacturer to Europe, or should you stimulate European companies that are busy and that are at the forefront of, for instance, the development of microprocessors for artificial intelligence applications, companies like Graphcore, for instance, should you stimulate those companies to scale and grow? Because we need to be at the forefront, not just of the technology, but also of the application. And that's where we have a number of important advantages, potential advantages, and with a 100 billion euro fund and the leverage it can muster, you can really try to make a difference. And I think we have the innovation and the research talent base. Let's mobilize it. So I'm pretty confident that there are opportunities there. But let's just not imitate what the others do, but let's come up with European solutions.
Thank you. Great approach. And we have here another question, also very hot topics right now, artificial intelligence and machine learning. And the questions are AI and machine learning an opportunity for Europe? Or do US and China have a stronger position and stronger policies in place? Not sure who wants to take one.
I can start on this. I think that, of course, they are an opportunity, and as Cohen said before, we should not copy the US approach or the Chinese approach. You should find a European approach. And in my view, the approach which has been adopted in the recent package on artificial intelligence by the Commission is quite good, because it is a good combination of an attempt to protect our fundamental values, the proposal for a regulation which considers the different uses of artificial intelligence depending on the level of risk. And some uses are prohibited, some uses are allowed, subject to some requirements, and for some users should respect transparency obligations, and less risky users are free. And this is about the protection of fundamental values and a proportionate approach. But interestingly, the package on artificial intelligence does not contain only the proposal for a regulation on the use of admissible uses of artificial intelligence, but it contains also a proposal of an action plan by European institutions and member states to foster the development of the use of artificial intelligence in Europe. And they focus on practical issues, not just on rules, on research, and they focus on a number of high impact sectors in which EU, because of what the European Union is currently, can obtain a leadership in artificial intelligence. Think, for instance, of the year of climate and environment. Also in Italy, we have in the energy sector very interesting uses of artificial intelligence aimed to better forecast the supply of renewable energy in order to better integrate renewable energies into the transmission network. Or think, for instance, of precision agriculture and how artificial intelligence can be helpful to combine sustainability objectives and an increase in productivity. And for food, Europe can be a leader. Think, for instance, of public services, think of, for instance, of health. In my view, the Commission is right in focusing on these sectors, because in these sectors, I think that, I believe that Europe can obtain a leadership worldwide.
Congrats. 1 minute final thoughts?
Yeah, well, I think just to highlight another issue where artificial intelligence is becoming quite hot today, and where Europe also has proper frameworks, I think, to ask and to impose everyone with artificial intelligence applications to deal with them, is everything that has to do with biases. Because you have to understand that the output of machine learning applications is fed by the data that you enter into those applications. So data biases create results that can be potentially harmful. And second, there's a huge need to understand why the algorithms give us the output they do. And the emphasis of Europe on understanding the algorithms and their results and understanding data biases because of the fundamental values that have to underpin our data policies is, I think, an area where Europe can also make a difference, because our companies, our research institutes, our universities will have to come up with solutions to deal with those challenges.
Great. This is such an interesting topic. I think I could stay here sitting with you and talking to this forever. But we only had this 1 hour time, and I would like to thank you so much for having time and sharing with us all this, your inputs on this amazing topic, and in particular also to those joining the webinar and being so active with the questions. Unfortunately, we didn't have time to go through all of them. But I wanted to thank you, all of you, and also remind you that the recording of this presentation will be made available on Cyber Council's website tomorrow. And please visit our website to register to our forthcoming webinars and also to read more about this and all the other topics related to IP and innovation. So thank you very much to all of you. Have a great day.
Thank you.
Thank you.
Thank you. Bye.
Bye.